The credit practices rule. The credit practices rule affects consumer contracts, including contracts signed in the purchase of a motor vehicle. The rule has three basic provisions. First, it prohibits creditors from using certain provisions that the Federal Trade Commission found to be unfair to consumers, which includes confessions of judgment, waivers of exemption, wage assignments, and security interests in household goods. And we're going to go over all these in just a moment. Second, the rule requires creditors, such as dealers, to advise consumers who co-sign loans about their potential liability if the other person fails to pay. And third, the rule prohibits late charges in some situations. This Federal Trade Commission rule applies to every single licensed motor vehicle dealer in the United States and applies to every motor vehicle transaction that involves financing, including buy here, pay here, third-party lending, and motor vehicle leases. So if you're sitting down with your customer, helping them get a loan or lease for a vehicle you're trying to sell, then you need to be aware of this rule. It prohibits confessions of judgment. In the past, certain consumer credit contracts, such as financing installment contracts used by automobile dealers, have contained language taking away certain rights that consumers of credit being sued would normally have. The language, which was usually called a confession of judgment, allowed judgment to be entered for the creditor automatically when the creditor sued the debtor for breach of the contract. The rule now prohibits creditors from including confession of judgment provisions. The rule's prohibition against confession of judgment, however, does not prohibit power of attorney provisions that still allow you to repossess and resell a vehicle, as long as these provisions do not interfere with the consumer's right to be heard in court. The rule is not intended to interfere with whatever rights a dealer has to repossess a secure property, such as a motor vehicle. It prohibits waivers of exemption. Previously, some dealer installment contracts contained what was known as a waiver of exemption, a provision that allowed a dealer to seize or threaten to seize specific property, in some cases other than the motor vehicle that was being financed. These waivers of exemption are no longer allowed under the Federal Trade Commission Credit Practices Rule. It also prohibits what we call wage assignments. In the past, if consumers did not pay as agreed, some dealer installment contracts allowed a dealer to go directly to the customer's employers to have their wages or some part of them paid directly to the dealer. The Credit Practices Rule now prohibits dealers from gaining what is called irrevocable assignments of money owed from salaries, commissions, bonuses, pensions, and disability benefits, as well as wages paid to the customer that has purchased a motor vehicle. However, the Credit Practices Rule specifically permits a dealer to use payroll deduction plans where your customer may choose to pay by regular deductions from paychecks. I would like to be clear, however, the Credit Practices Rule prohibition against wage assignments does not prohibit wage garnishment. If a dealer obtains a court judgment against a customer that has defaulted on a vehicle purchase, the dealer may still continue to use wage garnishment to collect that judgment, subject to the consumer protection laws provided by federal and state laws. The rule also prohibits security interest in household goods. Previously, some dealer installment contracts contained language that would allow a dealer to repossess many of the customer's household goods, such as refrigerators, washers, dryers, etc., if the customer did not pay for a vehicle that was being financed. Obviously, this practice has changed and is no longer allowed. The Credit Practices Rule does still allow your customer to offer what is known as a purchase money security interest, which could be, a piano, musical instrument, boat, snowmobile, bicycle, camera, and other similar items as security for credit to secure a motor vehicle loan. The rule also requires notice to co-signers. If a dealer conducting buy here, pay here financing, third-party financing, or leasing requires the customer to obtain a co-signer for the motor vehicle loan, the co-signer must be notified. The co-signer must be notified before they become obligated for the debt. And according to federal law, the following statement, which must be sent to the co-signer, you must use this, and this is in your manual, so if you're following along, you're going to be able to read this as well as I go over it. And it must specifically state, notice to the co-signer, you are being asked to guarantee this debt. Think carefully before you do. If the borrower does not pay the debt, you will have to. Be sure you can afford to pay it if you have to, and that you want to accept this responsibility. You may have to pay up to the full amount of the debt if the borrower does not pay. You may also have to pay late fees and collection costs, which may increase this amount. The creditor can collect this debt from you without first trying to collect from the borrower. The creditor can use the same collection methods against you that can be used against a borrower, such as suing you, garnishing your wages, etc. If this debt is ever in default, that fact may become part of your credit record. So this notice is not the contract that makes you liable for the debt. The cosigner notice must be in the same language as the agreement to which it applies. For example, if the agreement is in Spanish, then the cosigner notice must also be in Spanish. The rule also prohibits some late charges. Some creditors previously calculated late fees for delinquent payments using a practice called pyramiding of late charges. When one payment was made after the due date and a late fee was assessed but not paid promptly, all future payments were considered delinquent, even though they were in fact paid in full within the required time period. As a result, late fees were assessed on all future payments. In other words, each successive payment was considered short by the amount of the previous late charge, with the result that another late charge was soon thereafter imposed. This practice of pyramiding late charges is no longer allowed under the credit practices rule. That's the credit practices rule.